Chapter 15. Introduction to Mortgage Law. The transfer by the borrower of the equity of redemption to a subsequent buyer does not always relieve the borrower of the covenant to repay the debt. However, there are circumstances where the borrower may be relieved of liability on the personal covenant. Which one of the following events would not relieve the borrower from this liability? The borrower has sold the property with the knowledge of the lender. A court has power to reopen a mortgage transaction where, having regard to the risk and to all the circumstances, it is of the opinion that the cost of borrowing is excessive or harsh and unconscionable. In which one of the following statutes is this power contained? The Business Practices and Consumer Protection Act. In which of the following situations would bridge financing be the most advantageous form of financing for Jonathan? Jonathan and his wife recently had a second child and are looking to purchase a larger home. Jonathan and his wife have found the perfect home in North Vancouver, but their current home has not yet sold, and they need money for a down payment. Which one of the following is not an implied term of a mortgage? The borrower is entitled to assign the mortgage. The principle of good faith includes the duty of parties to a contract to act honestly in the performance of their contractual obligations. The court order usually obtained first in a foreclosure action is an order nisi. Which of the following statements concerning mortgages is false? A mortgage is a loan. An arrangement where a lender makes payments to a borrower over the term of the mortgage that are paid back at the end of the term is referred to as a reverse annuity mortgage. When an order absolute of foreclosure is obtained by a petitioner who is in the position of second mortgagee, which of the following is false? All other charges, liens, encumbrances, and interests registered on the borrower's title are foreclosed or wiped off the title. Under the British Columbia land title system, a mortgage is registered as a charge against the property of which the mortgager is the registered owner. Where a borrower believes that the amount of interest being charged is excessive, under which statute might relief be granted? The Business Practices and Consumer Protection Act. In British Columbia, a lender who holds a mortgage registered as a charge on an otherwise clear title to a borrower's land has an interest in land created by contract. A contract between a seller and a buyer whereby the seller agrees to sell its interest in certain property to the buyer for a price payable by installments and then to convey legal title to the buyer after payment of the purchase price in the manner agreed, is called an agreement for sale. Which of the following most correctly completes the phrase, a mortgage is? A contract, evidence of a loan, and security for a loan. Which of the following is not a common covenant of the borrower? Provision to waive the rescission rights under the Mortgage Brokers Act. When a mortgager grants a mortgage after having a registered first mortgage on title, the mortgager has created an equitable mortgage. Which of the following is not a requirement under the Interest Act in order for a borrower to tender prepayment of their mortgage? The lender is a financial institution. A mortgage is a document evidencing a debt owed by the mortgager to the mortgagee, which carries with it the mortgager's equitable right to redeem the property on payment of the debt, even after default. Under the Land Title Act, in British Columbia, a mortgage is registered on the title as a charge. Which of the following is not an example of an equitable mortgage? A mortgage that is unregisterable in the Land Title Office as it is prohibited by statute. Which of the following statements regarding mortgagees is false? Once the mortgage terms have been agreed to by the mortgager and the mortgagee is bound to advance the total amount of the funds when requested by the borrower, regardless of the terms of the mortgage. Which of the following is an example of an equitable mortgage? 1. Mortgage of the equity of redemption. 2. Agreement to execute a legal mortgage. 3. Mortgage by way of deposit of the duplicate certificate of title. The correct answer is all of the above. Which of the following statements regarding the effect of registration of a mortgage in a British Columbia Land Title Office is true? Registration of a mortgage raises only a rebuttable presumption that the mortgage is valid. A registered mortgage is not guaranteed under the British Columbia Land Registration System. Which one of the following is not a mortgage or covenant? To convey the property to the mortgagee, at its option, in exchange for an amount equal to current market value. A lender who is foreclosing may ask the court to appoint a receiver where the property being foreclosed is 1. A large residential apartment building. 2. A single-family dwelling with a tenant occupying it. 3. A single-family dwelling abandoned by the borrower. The correct answer is any one of the above. Which one of the following is not a provision of the Interest Act? No interest rate higher than 25% shall be provided for in a mortgage document. A mortgage of the mortgager's equity of redemption is called an equitable mortgage. ABC Loan Co., ABC, has agreed to lend $2 million to Devco Ltd. in exchange for a registered first mortgage against Devco's current residential construction project. The loan is to be paid out in 4 equal installments over a 5-month period, but all payments are at the discretion of ABC under the advances clause in the mortgage. The first installment has been paid, and it is now time to pay out the second installment. ABC has discovered that a builder's lien has been filed against Devco's property. You correctly advise ABC that, if the second installment is advanced to Devco, the lien claimant will have priority over this and any other advances made under the mortgage after the date of registration of the lien. After an order nisi of foreclosure is granted to a petitioner and the respondent borrower fails to pay the amount due as required by the order, the petitioner may apply for 1. An order absolute of foreclosure. 2. A judicial sale. The correct answer is either 1 or 2. Any clause contained in a mortgage that clogs the equity of redemption is void. A contract between the seller of real estate and the buyer whereby the vendor agrees to sell their interest in that land to the buyer for a specified price payable in installments and, upon payment of the price in full, to transfer title to the buyer is called an agreement for sale. Under the Environmental Management Act, a mortgage lender may be liable for the remediation of a contaminated site if the lender becomes the registered owner of the site. Which of the following contractual clauses in a mortgage could apply where the mortgage is otherwise in good standing but the borrower has not paid their property taxes? An omnibus clause. A mortgage that is granted, but for procedural reasons is not registrable, is recognized as a present equitable mortgage. An option to purchase the mortgaged property given by the mortgager to the mortgagee at the time the mortgage is negotiated is void. An option to purchase the mortgaged property given by the borrower to the lender at the time the mortgage is negotiated is void. Which of the following clauses contained in a mortgage would constitute a clog on the equity of redemption and therefore be void? Option to purchase clause. In a mortgage transaction, the mortgagee is granted the mortgage as security for a loan. After a borrower has given a mortgage of real property, the borrower's remaining interest is described at law as the equity of redemption. Which of the following statements about federal legislation governing mortgage interest rates is true? The Interest Act provides that if a mortgage agreement does not specify the rate of interest chargeable, the rate allowed by law is 5%. A term of the mortgage provides that the full outstanding balance will become due and payable in the event of default by the borrower in making any payment. This term is known as the acceleration clause.